Sports are America's #1 form of entertainment, but with that comes a major responsibility of teams ensuring the protection of trademark laws, even at the expense of their fans. Sports also encompass a very large financial market and attract fans from across the country, but what goes on behind the scenes with trademark laws is alarming, and the fans need to be made aware of these happenings. Although trademark laws can present unexpected challenges, they are essential for ensuring business and consumer success and safety. Quote, in the 1950s, because of the increasing popularity of professional and sports and corresponding revenue-generating potential major professional sports league teams individually began to license third parties to manufacture and sell trademarked merchandise. End quote. That's from Mitten. Context such as this from over half a century ago highlights how long this has been occurring in sports. My research is thorough and will uncover the truth about trademarks in sports. In the following points, I will begin discussing how trademarks can make the sports industry big money, how even the biggest sports fans can be betrayed by their favorite teams, and how hard it is to get sports teams trademarks, which leads to tremendous financial impacts. But before we dive deeper into the important role trademarks play in the sports world, you need to understand what a trademark is, what trademark law is, and what the Lanham Act is. First, a trademark is a word, phrase, logo, graphic, symbol, or other device that identifies the source of a product or service and distinguishes it from its competitors. So what is trademark law? Trademark laws protect a business's commercial identity or brand by discouraging other businesses from adopting a name or logo that is confusingly similar to an existing trademark. So what exactly is the Lanham Act? Well, the Lanham Act provides a national system of trademark registration and protects the owner of a federally registered trademark against the use of similar marks if such use is likely to result in consumer confusion or if the dilution of a famous mark is likely to occur. One other thing you need to understand about the Lanham Act is how violation acts under it. To establish a trademark infringement claim under the Lanham Act, the plaintiff must demonstrate that the plaintiff has a valid and legally protectable mark. The plaintiff owns the mark, and the defendant's use of the mark has caused a sense of confusion in some shape or form. Although trademark laws can present unexpected challenges, they are essential for ensuring business and consumers' success and safety. Over the next few minutes, I'm going to briefly discuss 3 court cases and 7 other situations that involve sports and trademark laws in some shape or form. I'm also going to discuss how they affected the team or the other party involved. Now, hold on to your ball caps because we're in for a long game. In one of the first articles I read, From Dallas Cap to American Needle and Beyond, Antitrust Law's Limited Capacity to Stitch Consumer Harm from Professional Sports Clubs and Trademark Monopolies, it discusses and talks us through the history of antitrust laws, trademark, and development of how the sporting industry came to make millions off their trademarks and how that has affected its fans. It walks us through about how hard it is to get the trademark just to put on a team's logo on your own merchandise, or even pictures due to the collective exclusive trademark licensing. It's all a money game, and trademarks are just there to benefit the sports teams and not the fans or the people who enjoy the game. The first case I'm going to discuss is Major League Baseball versus Salvino, which is a case involving the MLB and Salvino, which is a company that sells and distributes sports memorabilia, which includes but is not limited to stuffed animals that are usually designed as replicas of sports celebrities. Salvino had several agreements and licenses with the MLB to use several teams' logos and players' names on the plushes. Ultimately, the company grew so successful that many MLB clubs partnered with the company to offer partnered giveaways with the teams. However, the lawsuit came into action when Salvino used the Arizona Diamondbacks logos, one that they did not yet obtain a license for. After fighting it out, the court ruled in favor of Salvino and found the MLB's case to be without merit. One would think that trademarks would present the most troubles to companies, but they have also presented troubles to even the most dedicated fans. Trademarks and laws associated with them have also brought many challenges and disappointments to fans. Some may even say the team's superfans. Without superfans, many sports teams would be at a loss of profit. which is why so many sports teams encourage their superfans to come back year after year and continue to provide support for their teams in countless ways, all leading to financial success for the team. A hardcore Los Angeles Clippers fan named Daryl Bailey had been attending every single Clippers game for the past 15 years. And since he was so dedicated to his team, he was known in the stadium as Clipper Daryl. The Clippers even noticed his dedication and supported him in various ways for several years, even by placing him on their website. This was until the Clippers deemed it appropriate to bring a successful trademark infringement claim against the longtime fan, since he was selling his own merch and using Clipper in his name multiple times. So they cited that the infringed use will likely cause consumer confusion, which is why they brought the infringement claim against him. In the end, since the team is protected by the Lanham Act, it is hard to rule in favor of Mr. Bailey. But it just goes to show that nobody is safe from trademark laws, even the most dedicated fans. As we now see, not even the biggest sports fans are protected from trademark laws. You begin to wonder, why are teams so strict about these violations? The one answer is money. Trademarks for sports teams seem to just be a big money game, and it even seems that way for one of the biggest sporting events in the world, the Olympics. Oftentimes, instead of springing into a lawsuit, many companies and organizations will send out a cease and desist letter to protect their intellectual property and trademarks. This is essentially a warning to stop the illegal activity before it goes any further, which is what the Olympic Committee is found to be doing quite often. The United States Olympic Committee is found sending these letters for anything and everything, such as instances where the word Olympic was used incorrectly, improper clothing using the wording, or copyright infringement of the Olympic rings. This commonly shows just how worried they are about even the smallest businesses or individuals gaining money and, as a result, taking it from their commission. Another instance that showcases this is sports leagues showing more interest in the money that trademarks provide them than the common good for others. A pristine example of this is in the college athletics, NCAA, related to controversy of collegiate athletes getting paid. In 2015, Johnny Manziel was one of the most popular names in college football, leading him and his name to make a lot of money from merchandise and memorabilia. During his time at Texas A&M, he wanted to trademark his nickname, Johnny Football. Athletes had not been able to make money off of their name or any merchandise they were selling without needing to, quote, obtain federal trademark registration of a name or nickname so that they can recover a salary in the form of trademark licensing royalties, plain and simple, end quote. This was the NCAA's way of showing athletes that they could still earn money, just not through the use of trademarks. This instance was back in 2015, whereas now this problem is even more evident today as we see the rise in popularity in college athletics through the money being made through their name, image, and likeness deals. There needs to be a better way to provide athletes with access to trademarking their names and slogans. With technology rapidly growing, the sports world is majorly impacted by its growth. Friend or Foe by Bari Solomon explores how technology is impacting sports teams and organizations, specifically their copyright and trademark laws. As the article progresses, it references several times that trademark infringement has occurred because of social media in today's digital age. Since the world is rapidly progressing, sports teams and social media outlets could make it easier and better for users to understand what copyright and trademark laws are so they don't violate them more frequently and constantly. In a case brought on by John Facenda against the NFL Films Incorporation, the plaintiff, which was the narrator in the situation, brought an action against the NFL and other defendants alleging false endorsement and unauthorized use of a name and other claims based on the use of the narrator's voice in a television production about a football video game. As the case progressed, they found that when the video game was shown on television, it was a commercial speech and therefore was not covered under the artistic expression in the First Amendment. As a result, the NFL had a right to release it without letting the plaintiff know or agree to it. As for trademarks, the plaintiff would have to prove that the video game and what was done legally protectable owns the mark, or the defendant's use of the mark would produce harm, conditions, or a violation of the Lanham Act. This just goes to show that you need to pay attention to what contracts you are signing and what the agreements are before you necessarily sign that contract. Because 10 times out of 10, the trademark and the company that owns that trademark is going to win over your case. Even the biggest companies have to enter trademark agreements with other big companies. In an article by Sarah A. Padove, It talks about how the Major League Baseball entered into an agreement with the company Topps Baseball Cards to grant them exclusive rights and access to the use of MLB trademarks. This left a longtime competitor of Topps Baseball Cards, Upper Deck, sidelined since they could no longer be able to produce any cards with the MLB logo or team logos due to the Sherman Act. This deal caused the MLB to look deeper into the Sherman Act and eventually revoke and remove their antitrust. Since the antitrust laws are now removed, it now helps businesses stop conspiring with one another and competing with one another for businesses, and it has affected the MLB up to this date. As we've seen, trademark laws and acts have made history and have been very helpful for certain situations. In this next situation, it's a court case against NBA properties in Yonzo. The court case includes the NBA, National Hockey League, NBA, and MLB. The NBA was the company to pursue the case, citing trademark infringement and counterfeiting. In summary, the defendant was manufacturing and selling all articles of clothing using multiple leagues' trademark logos, which is illegal. As a result, the plaintiff was seeking money for damages, which was later awarded. Trademarks are everywhere. Trademark violations come in all shapes and forms, but when it comes to your favorite sports teams, some people don't want their team to ever leave their city. Keeping the home team at home discusses how the relocation process for sports franchises can be a long, drawn-out process and what legal processes are taken to slow teams from wanting to relocate and actually executing the move. The article dives into detail about how the NFL, for example, should take the following steps to prevent less relocations. Quote, exclusion of the NFL's relocation control from the antitrust law, an enforcement solution, enforcement by the NFL of its rules adopted that require pro-competitive reasoning before disallowing a move, and a trademark solution, enactment of new rules by the NFL that force relocating teams to leave their team names, color, and history in the city they abandoned. End quote, Nottingham 1. Although trademark laws can present unexpected challenges, they are essential for ensuring business consumer success and safety. No one, even those who dedicated their lives to their favorite sports teams, are safe from trademark infringement, so fans must ensure they follow all precautions to make sure trademark laws are not violated. Trademark laws are simply a money scheme to sports corporations at all different levels of play. Despite the cloudiness trademark laws bring about, they are essential for ensuring business consumer success, even if it comes at the expense of fans, athletes, and even small businesses.